Welcome and thank you for standing by. At this time, all participants are on a listen-only mode. During the question and answer session, you may press star 1 on your touch-tone phone if you would like to ask a question. Today's conference is being recorded. If you have any objections, you may disconnect at this time. Now I would like to turn the meeting over to Ms. Linda Abbruzzese. Ms. Abbruzzese, you may begin. If you need assistance, please press star 0.
Thank you very much. Good afternoon for those of you joining on the East and West Coast, and thank you for those of you who are joining from Mexico. Thank you for joining us for our Exporting to Mexico webinar series, How to Settle Disputes with Mexican Customs webinar. This is the last and 7th webinar of our Exporting to Mexico webinar series, so thank you very much for joining us. This webinar is brought to you by the U.S. and Foreign Commercial Service of the Department of Commerce and AVG Derecho y Comercio International. My name is Linda Abbruzzese, and I'm a Senior International Trade Specialist for the Global Knowledge Center for the U.S. Commercial Service, and I will be today's moderator. In a moment, I'll turn this presentation over to Mr. Manuel Velasquez, who is a commercial specialist in our office in Monterrey, Mexico. Also, our main speaker for today's webinar is Mr. Carlos Alberto Arevalo Garza, who is a partner in litigation in the international operations of AVG Derecho y Comercio International. This webinar will talk about the U.S. and Mexican customs laws when exporting your products into Mexico. It will also discuss what tools you need to solve any disputes at the Mexican customs and any other resources that could help you when working with the Mexican customs. Speakers will be available at the end of this presentation to answer your questions, and also contact information will also be provided. Now, for those of you who just joined, you can still log into this webinar by entering the URL, website, and passcode per instructions that were sent to you by email. And we do have a few housekeeping details to make sure everyone gets the most benefit from today's webinar. You'll be able to hear this presentation via your telephone and view it simultaneously via your computer. So if you're not hooked up through both, please take a moment to do this. And if you're experiencing any technical difficulties, please press star 0 anytime during this presentation. And in this presentation, we will be taking voice and written questions. To ask a voice question, please press star 1. To ask a written question, we invite you to type in your questions on your screen as they occur to you during this presentation. There is an icon with the letters Q&A in the upper left-hand side of your screen. The Q&A stands for question and answers, where you can click and type in your questions anytime during this presentation. We will compile the questions at the end of the webinar and present them as time allows. Type questions which are not answered during this webinar due to time constraints, we will get back to you via a personal email. So now I'd like to introduce live here from Washington, D.C., but also live in Monterrey, Mexico, Mr. Manuel Velasquez, who is a commercial specialist in Monterrey, Mexico. Thank you very much, Manuel, for joining us.
Hey, hello to everyone. I'm Manuel Velasquez here in Monterrey, Mexico. I want to talk to you about the U.S. Commercial Service here in Mexico. We have 3 offices that we make promotion for the export in Mexico. We could help you with your products if you want to enter to the Mexican market. We could be your source, doing several kind of services like matchmaking services, market research, international partner search. We have several kind of services that we could help you with your export in Mexico. And we find out that one of the most important services that we could provide you is the customs research or customs question that you could have when you are exporting to Mexico. If you have any kind of questions about regulations, about how to export in Mexico, how is the processing in Mexico, we could be your first source, and we could help you with market research, with custom broker list, or if you have any kind of questions, if you already have problems in the Mexican customs, or do you want to know what is the requirement for your products, please be sure to take note of our contact information, and we can help you providing you more information about your specific questions. Now, I have here with me Carlos Arevalo, who is going to be our main speaker for this very interesting webinar. Carlos?
Thank you, Manuel. Good afternoon to everyone, and thank you for your interest in this webinar. I also want to thank the U.S. Commercial Service for the invitation to participate, especially Linda in Washington and Manuel here at the U.S. Consulate in Monterrey. I'm a Mexican attorney specialized in Mexican customs and international trade law, and for the last 16 years, I've seen all kinds of disputes with Mexican customs. Based on my experience, in this session we will review some current issues that may cause disputes with Mexican customs, learn about mechanisms that the Mexican law provides to settle them, and finally, review some suggestions that will make you better prepared in case of an audit or verification by Mexican customs. Before we talk about possible issues or problems that may normally cause disputes with Mexican customs, and because this webinar is intended primarily for U.S. exporters, it is important to clarify from a legal standpoint when a U.S. exporter can get into trouble with Mexican customs to begin with. This can happen in two ways. Directly, when the U.S. exporter becomes a Mexican importer of record, which is very rare, and we'll discuss it later, and also when a certificate of origin is issued under NAFTA to export U.S. originating goods to Mexico, which is a very common scenario. Also, a U.S. exporter can enter in dispute with Mexican customs indirectly when the Mexican entity, that is the Mexican importer of record, is a related party to the U.S. exporter. So, passing to the next slide, who is a Mexican importer of record? A Mexican importer of record is any individual or corporation can become an importer of record. And according to the Mexican customs law, the importer of record will be liable for the payment of all applicable import duties and for the compliance of non-tariff barriers. By law, to become an importer of record, the person must be registered as a taxpayer in SAT, which is the Mexican equivalent of the IRS, Tax Administration Service, under any of the available income tax regimes. The person must be in good standing with SAT. The person must also be registered as an importer in Mexican Customs List, which is the importer registry. And foreign citizens and corporations may register and become importers of record as long as they are registered as taxpayers under the applicable income tax regime. Now, I just want to clarify this last point. As I said, foreign citizens and corporations can be importers of record, but it is very rare. I've only seen one case in my experience, and it was for a specific company that needed the transfer of goods from the U.S. to Mexico for a specific reason. The main reason that this is very rare is because specifically U.S. exporters want to avoid liability from customs. So my recommendation always is, as a U.S. corporation, do not become a Mexican importer of record unless it's extremely necessary. So going to the next slide. When do problems arise with customs? Basically, customs will have contact with importers, exporters in several verification scenarios. The first one, when goods are cleared at the border. After this happens, audits can also be made of foreign goods during transport in Mexico. The most common in these times, because the barriers are being less strict at the border, but now customs is making more audits in the importer's registered address, which is similar to what happens in the U.S. with CBP now. And the fourth scenario, origin verifications with producers and exporters in the U.S. and Canada. The first three scenarios will only involve the Mexican importer of record directly. In the fourth scenario, origin verification, the U.S. exporters will be involved directly and have direct contact with Mexican customs. So let's now see the first three scenarios. The next slide. What do customs look for during verification? They basically look that the goods have proper import documents, that the proper classification and valuation of goods is made. They look for errors in the customs declaration that may affect the statistical data. They look for compliance of non-tariff barriers. They look for omissions in tax and anti-dumping duties, illegal preferential tariff applications, and timely return of temporary imports, which is mainly for EMEX corporations or Maquila. So let's now talk about a little bit more of these cases, and specific problems are common in classification and valuation. The U.S. and Mexico both work with the same harmonized tariff system. Because of this, the first 6 digits of tariff numbers are the same, although keep in mind that classifying goods always involves a subject opinion and verification by customs. And this is a specific issue that I've seen that causes many troubles between Mexican exporters and, between U.S. exporters and Mexican importers, because sometimes the tariff classifications are not the same. They should be the same in the first 6 digits, but at the level of 8 digits will be different because Mexico has a specific law that determines this final digit. So as long as the first 6 digits are the same, I think you're in the same page with the Mexican importer. If not, I think it's important to verify the classification, and this will be important, as we will see in the next slides, in order to avoid potential problems with customs. So classification is crucial in order to determine also the applicable duties to be paid and non-tariff barriers that must be complied with. There's a great website that everyone can check out, which is CSEX, and this is a great tool maintained by the Ministry of Economy of the Mexican government, and you have access for free to verify the Mexican tariff system and the applicable duties for each tariff number. So in an import process, what happens is normally the Mexican customs broker determines the applicable tariff number or tariff code for the goods that will be imported to Mexico. You can verify this code in this website to see all the applicable non-tariff barriers and duties that will have to be complied at the border. We understand that it's not always easy to determine the applicable tariff number for certain goods. The Mexican customs law does provide an advanced binding ruling option regarding tariff classification that you can also try. Mexican customs normally provide tariff classification services under HTS, but it's always wise to verify with Mexican custom brokers' conclusions with independent counsel. If there is doubt between 2 or more applicable tariff numbers, the customs broker may many times play it safe to avoid liability when high duties or non-tariff barriers are at stake, leaving the burden of compliance to the importer. So just remember that you have this tool by law, and you can ask directly to Mexican customs to determine the applicable classification. Now, the next slide is concerning valuation. Regarding valuation, recently a great effort has been done by the Mexican authorities to attack documented contraband, which is most times occur by means of the declaration of undervalued goods. So this is a very important case that you need to take care when exporting goods to Mexico. By law, the value of goods is used as the base for the calculation of import duties, taxes, and sometimes fines. So you can imagine the importance of this for customs. Therefore, to avoid problems with Mexican customs, it is very important to determine the value of goods according to the Mexican customs law, which follows the standards set out by the World Trade Organization. The U.S. and Mexico are part of the World Trade Organization, and therefore their systems run under the same rules. The basic principle applied is the transaction value of goods, which is normally shown on the invoice. If there is no transaction value available or is not acceptable because of distortion, for example, when parties are related and such relation affects the value declared in the invoice, the following methods are used in succession: transaction values of identical goods, transaction value of similar goods, deductive method, computed method, and fallback method. This is very, very specific and very dense, but also you can also always rely on counsel to determine the correct valuation if in doubt. Normally, if there's market value being used for the product and the invoice reflects that, you won't have any problems with customs. When the transaction value is not available, valuation may be a difficult task. Also, when in doubt, an advance ruling may also be available from Mexican customs. Another hot issue for customs when they do the verification process, the next slide, is non-tariff barriers. Non-tariff barriers, for those who are not familiar with the term, are measures that regulate or restrict the import or export of goods from or to Mexico for multiple purposes not related to taxation. For example, to maintain the balance of the national economy, to preserve national security, ecological balance, animal, plant, and human health, anti-dumping measures, to control the entry of used goods or waste products, among others. Also, the most common non-tariff barriers are what we call in Mexico NOMS, which are Normas Oficiales Mexicanas in Spanish, in English, Official Mexican Standards, that regulate products, processes, services, when these may cause a risk to people, animals, plants, and the environment in general. NOMs are normally required to be complied through the appropriate labeling of the product or through safety certifications performed by specialized entities. The key for knowing which NTBs are applicable is the tariff number. So again, we stress the importance of a correct classification of the goods. All federal government agencies that require NTBs for import or export of goods use the tariff code as reference to identify the goods that are subject to compliance. This is, again, another reason why the correct classification of goods under the harmonized tariff system is crucial to avoid NTBs that may not be applicable. Your Mexican custom broker will always assist you in this matter. By law, they are responsible for ensuring that the importer complies with all NTBs before the import process is made. CSEX, which is the website that I mentioned in some slides before, will list also the applicable NTBs for each tariff number for easy reference. And now, this last part is very important because we just had major changes in the Mexican customs law last December. Post-clearance of NTB compliance is only allowed in few cases. Before, if you didn't comply with a certain non-tariff barrier, customs will normally seize the goods until you comply with them within a period of 30 days. Well, this is now very limited, and only a few cases which only involve labeling or certain non-tariff barriers that do not involve animal, plant, or human health or security reasons or ecological reasons are allowed to be complied post-clearance. So this basically means that if you omit a certain non-tariff barrier, your goods will be seized and you would lose them because you would not have the opportunity to comply post-clearance. The next slide. So advanced binding rulings. We're talking about this option for importers to obtain legal certainty of their operation, thus reducing the risk of liability in the verification process. And I wanted to mention this specifically for you to remember that you have this tool. In general, Article 34 of the Federal Fiscal Code in Mexico requires Mexican tax authorities to answer any request done by individual taxpayer by means of a ruling, as long as it regards a specific and real situation. So if you have a specific question about a real import that will be made, the Mexican tax authorities are obligated to answer. These rulings, when favorable for the taxpayers, are binding for them only for the specific case that is consulted. It may not be applied to similar cases, and for each, if the case is similar, a separate filing must be made. When the rulings are not favorable for the taxpayers, they are not binding for them and may not be challenged. This is very important because before, many times you would do this to obtain a ruling for customs, and then you would go into litigation because you knew that that ruling or that way of thinking of the authorities was illegal. They changed the law to avoid that. You must wait until a specific application of the ruling in a specific case to be able to go to litigation after that specific application of the law. So, to summarize this, Mexican authorities must answer within 3 months a petition and sometimes 4 months. I normally see 1.5 months as the minimum that you have to wait for an answer. The next slide. In foreign international trade, we basically see 3 types of advanced binding rulings that are used, which is tariff classification, which we have discussed before, valuation of goods, and also a third one, which is NAFTA advanced ruling to secure country of origin certification. We will see origin verifications in the next slide, but it is important to mention now that many Mexican importers are having big problems with customs due to problems with certification of origin made by U.S. and Canadian exporters. So this is very important. This is very important mainly for the importer of record to know that they can get a ruling in advance before making the import process. They can ask customs to verify if the goods are originating in order to avoid future problems in case of an origin verification that we will see in the next slide. So that's also a very good tool that you must keep in mind that can be used. So what happens when something goes wrong during an audit or a verification by Mexican customs? When Mexican customs consider that duties were omitted or fines are applicable, but there is no cause of seizure, the shipment is released immediately. They won't hold the goods for any reason. When an irregularity is found with or without seizure of goods, an administrative procedure must be initiated by Mexican customs by means of a preliminary determination, which has to state clearly the nature of the irregularities found during the verification and the possible liability that may arise. Remember, in Mexico, the importer and the customs broker are both liable. It's not like the U.S., which the customs brokers normally are not liable to customs. The customs brokers, the Mexican customs brokers are liable in a solidarity way with customs, so they are concerned that everything is in order with customs. So that may help you as an importer to avoid major problems with customs. When an administrative procedure is initiated, the importer and customs broker are given 10 days to offer any evidence or arguments that may prove that the Mexican customs preliminary determination is unfounded. Here it's very important to mention that many importers try to fix these problems by themselves with customs without proper counsel. This is a very important step of the administrative procedure that must be considered with experienced counsel at all times. So don't wait until litigation stages. Many cases can be resolved at customs level without litigation. So that means less costs, less headaches, and most importantly, when the goods are seized, normally they will remain seized until litigation ends, and this can go to 1 year, 2 years in some cases. So don't wait until litigation to get advice from experienced counsel. Every year, Customs publishes a list of regulations with a series of benefits for importers subject to verification. Also, the taxpayer rights law may also be applicable to avoid fines, and these benefits can only be used during this stage and are not available after a final determination is issued by Customs. So, also in relation with this, we were talking that in some cases goods are seized. So, when are, by law, goods seized by Customs? Next slide. This is strictly regulated by the Mexican Customs Law, by Article 151. And here we state 6 causes for seizure. The use of an unauthorized point of entry for the import of goods, the deviation of goods or entrusted between Customs Office is cause of seizure. It's not very common, but it's normally for illegal contraband that may be applicable, not for the normal part of the commercial trade. The second one is applicable for normal trade, which is the non-compliance of non-tariff barriers, import of prohibited goods, omission of anti-dumping duties. I just need to clarify regarding a specific labeling norms, which is a non-tariff barrier, as we mentioned before. Not complying with labeling will not cause the seizure of goods, but Mexican Customs will delay the release of the shipment until the labeling is done. And basically, they just give you 30 days to do that. After you comply with labeling, they will let you continue with the import process. Goods that are not declared or lack proper legal import documents, which is common. Many times, an entry document has goods that are not declared that were included by error, so those are seized until they're clarified. Not declared goods in excess of 10% of the total value of the customs declaration is also common. But these are common mistakes and that do not have real consequence at the end. Because, as I mentioned, during the administrative procedure, there are specific benefits that the customs law provide to importers in order to fix the situation and obtain the release of goods. False name or registered address of the importer, false invoices. This is very important. Many times, pro forma invoices are used, and Mexican Customs verifies with the U.S. exporters if the invoices are real. You may issue a specific invoice that maybe the Mexican Customs broker does not use, sometimes with permission, sometimes without permission. So it's very important to have a tight team, U.S. exporter, Mexican importer, and customs broker to avoid these type of problems, because the goods will be seized if something doesn't check out. And also the importers many times change their registered address for tax purposes, and they don't notify the tax authorities of this. So regularly they are checking if they still exist if they're still be able to be localized in the former address, and if they do not find the specific company in the address that is stated, they will seize the goods for that importer in all cases until this is clarified. And the last one is the value of goods, which is what I mentioned, a new strategy of the Mexican Customs to avoid documented contraband. When value of goods declared is lower in 50% or more with regard to the value of identical or similar goods, they have a big list to compare. And also they monitor previous imports of competition and also of the same company that are making the imports. So they have way to see, especially when goods are coming from China, when goods are undervalued. So this is a big issue right now in Mexican Customs, which is helping to avoid contraband. So final determination. As we said, an administrative procedure has to be initiated when there's an irregularity or when goods are seized. In all cases, 10 days are given to provide evidence. And after this, Customs has a maximum period of 4 months to issue a final determination to end the procedure. They normally take 2 to 3 months, even when the goods are seized. So this is why I stress preliminary work before the import process is made is crucial to avoid potential causes for seizure. Because once the goods are seized by Customs, you must wait normally for 3 months to obtain a final determination to end the procedure. And I'm going to be very honest with everyone. It is mostly the case, even when you present evidence, that Customs will issue a final determination with a tax assessment and determine that the goods are deemed now property of the state. Because they have strict controls to avoid corruption, and many people who work at Customs try to avoid that liability. So they prefer a higher court to determine if the seizure was right or wrong, but this takes time. So again, preliminary work is very important to avoid a seizure, because once you have a seizure, expect to have great delays to obtain your goods back. So this is very important. If the 4-month period is exceeded, all goods must be released without liability. This was very common 10 years ago, but not anymore. Customs is working very efficiently to avoid losing taxes and goods by this formal cost. So you will receive in 3 months tops your final determination. And this final determination will indicate if the seized goods should be released and if the importer or the Mexican Customs broker is liable for the payment of duties or fines. So this basically shows the first 3 scenarios of verification that we mentioned, how the procedure works, and at the end, how a final determination is issued by Customs. And I just need you to remember this final step of a final determination before we analyze further litigation in the other stages of litigation. I want to speak about now of origin verification under NAFTA, which will carry a similar procedure that we saw, but is now regulated by the international treaty and not by the Mexican Customs law. At the end, you will receive also a final determination that would be similar to the one we just saw in the previous slide, and at that point we will talk about the litigation options that we will have in the 4 scenarios. So again, this is the 4th scenario, which I mentioned could involve directly the U.S. exporters and the Canadian exporters that issue NAFTA certificates of origin. So the Central Audit Administration of Foreign Trade Operations is the Mexican Customs Authority in charge of origin verification procedures. Remember the name. In Spanish, it's the Administración Central de Auditoría de Operaciones de Comercio Exterior. This is the only authority now in Mexico that is in charge of these origin verifications.
Can you name it again, the agency?
The Central Audit Administration of Foreign Trade Operations, which is Administración Central de Auditoría de Operaciones de Comercio Exterior, the first name that you have there on the slide. And this authority can carry out 2 types of verification procedures under Article 506 of NAFTA. The first one, which is the most common, because it implies less costs for the authorities, is the verification initiated through questionnaires sent by courier services, FedEx, UPS, DHL. The second type is a visit, direct visit by Mexican Customs to the U.S. facilities of the exporter who signs the certificate of origin. So let's talk about the first type, the questionnaire, which is the most common. Questionnaires are sent to U.S. exporters or producers by courier services, and 30 days are given to the exporter or producer to answer this questionnaire. All questionnaires are sent in Spanish, but this caused a lot of trouble in the past years, and also many tax assessments made as a consequence of these procedures were turned down by the courts because of this. So a courtesy translation to English is now included. Also, it is very important that the U.S. exporters have a good system to verify who receives the courier services or the mail in their companies, because many cases Mexican Customs are saying that the documents or the questionnaires are delivered to the company, but the appropriate personnel to answer these questions never receive them. So this has caused a lot of trouble because, as you can see there in the graphic, if the questionnaire is not answered, a second questionnaire is sent, and 30 days are given for a final response. Also, in this case, a notice of preferential tariff denial is sent if no response is received. From the 100% of questionnaires that are sent, the Mexican authorities say that 40% answer, 60% do not answer. From our point of view as litigators, the main cause of this was that the means of notification used by the Mexican Customs were illegal. They used not even UPS, FedEx, or DHL. They used a very local courier service called Redpack, which really did not have any way to verify who was the person in the company who received it, and if the proper competent person to answer the questionnaires actually received it. So many cases were also won because of this issue. Mexican Customs now is very careful in using better courier services and also trying to contact by other means the exporter or the producer. So also, when you sign a certificate of origin, make sure that the contact information that you include in field 11, which is the last one, is updated, and also mentions the person who is responsible for the determination of the origin of the goods that are being sent. So again, returning to the graph that you see in the slide, if the second questionnaire is not answered, a final determination in writing is issued 4 to 10 months after the initiation or after the first questionnaire is sent. In the right side of the slide, if the questionnaires are received and are answered within 30 days, Customs can also send a notice of possible preferential tariff denial if the information or documents are not sufficient or precise enough. At the end, this procedure will end with the final determination in writing 4 to 10 months after the initiation. And the two possible outcomes of this procedure will be the denial of the preferential tariff treatment or the confirmation of the preferential tariff treatment. And in the next two slides, we'll see the consequences of this. But before this, I want to briefly discuss the verification procedure that occurs when a visit is made to a U.S. exporter, and then we'll see the consequences of preferential tariff denial. So the next slide. So option 2, the Mexican authorities want to visit you in the U.S. A proposed date for a verification visit is notified to the U.S. exporter or producer. Customs and Border Patrol is also notified of this. You have 30 days to answer and accept the visit. Now, this is very important. Many times we are not prepared for the visit. Just avoid not answering. Answer and accept the visit, but negotiate another date that will be better for your company to receive Mexican Customs. They are willing to do that. The important thing is that contact is made with them. Because if the U.S. exporter or producer, as you see on the left side of our slide, if the U.S. exporter or producer does not answer or denies authorization for the visit, automatically NAFTA determines that the preferential tariff treatment can be denied, and a final determination in writing is made. On the right side, if the U.S. exporter or producer authorizes the visit, personnel from Mexican Customs will attempt to initiate verification on the negotiated date. If additional information or documents are required after the visit, 30 days are given to file them. A notice of possible preferential tariff denial is sent if information or documents that were sent in response to the questionnaires are not precise or sufficient. And the same time frame applies, 4 to 10 months for a final determination in writing, which can deny preferential tariff treatment or confirm preferential tariff treatment. So let's see the consequences now. Well, actually, the consequences are in slide 21. Here are some specific recommendations or suggestions for you to avoid problems with a verification procedure. Good record keeping is essential. To be able to prove the origin of the exported goods and the materials used in the production process is key to avoid problems with customs during a verification process. Fully cooperate with the Mexican authorities, providing all the required information in a clear and precise way. Always answer questionnaires on time. If you need more time to file additional documents, Mexican authorities are always willing to negotiate a deadline as long as initial contact is made. Always accept verification visits. You can always negotiate a better date to be better prepared. Notify Mexican importers. This is very important. Notify Mexican importers of any changes that may affect the exported goods origin and of any verification procedures initiated. Remember, their preferential tariff treatment is on the line here. So they are very interested that this treatment is not denied by customs. And contact directly the Mexican Customs. It's okay. They have a very good site, a microsite actually, in that link that you can see there. And then the next slide you'll see actually a picture of the microsite, which is in English. And you can see that they're trying to inform the U.S. and Canadian exporters of these types of verification processes that they're making, procedures. So they even give you the direct contact information of the head people who work in this area. And they are willing to answer questions and explain why they are making these types of verifications. So please, it is okay to contact them. Always have counsel if you think you may have issues. But it is always okay to contact them directly, just for the initial contact, for them to see that your company exists, that the operation was real, that we're not talking about fraudulent documents, and that you are willing to cooperate in order to prove that the origin of goods is correct.
One question here: if the U.S. exporter wants to contact these people from the SAT, they're answering in English or in Spanish?
In English. In English. They have people, the bilingual people, prepared to do that. Yeah. So, what are the common irregularities found in these verification procedures? Exporters show lack of knowledge regarding their obligations when they issue a NAFTA certificate of origin. Importers and exporters many times consider made in the U.S. as an equivalent to NAFTA originating, which is not always true. Exporters forget that their goods must meet the NAFTA rules of origin before issuing a certificate of origin. Exporters change their address or relevant information declared in the certificate without notifying the importer. The exporter does not keep records to prove the origin of goods exported to Mexico. And this comes directly from customs. So they know that many times exporters certify goods as originating when they're not really sure that they originated, or maybe don't have the proper trained personnel to determine according to the NAFTA rules of origin to do so. So if you're gonna certify as NAFTA originating, be sure to have the proper expertise and documents to back that certification, because you will get, or it's very probable that you may get a visit or a questionnaire from Mexican Customs. And the U.S. does the same in Mexico with Mexican exporters that certify here goods. And they do this, and they're stressing this because it mainly involves taxes that are not paid, and they know that many exporters don't have the proper knowledge to do so. And the main objective for you to know of the verification procedures is actually first to determine that the operation actually happened, that we're not talking about of fraudulent documents. And in a second stage, they want to determine if the origin of goods was correctly determined. So, for the next slide, what are the consequences of a final determination? Because many U.S. exporters may be thinking, well, okay, I get an origin verification, my preferential tariff, or the importer's preferential tariff treatment is denied. What are the consequences for me as a U.S. exporter or as a Canadian exporter? In my opinion, they should be worse, but they're really not. The main burden falls for the importer record, because the importer record is the one that applied for the preferential tariff treatment. That's the same answer that a CBP officer will give you in the U.S., and that's the same way of thinking that happens in Mexican customs. I think they should be liable for the incorrect certification, but there's no mechanism to sanction this by Mexican customs to the U.S. exporters. This is formally speaking, but I do have to mention that when a U.S. exporter receives a final determination in writing that the goods are not NAFTA originating, an internal flag is raised within Mexican customs to audit all exports from the specific U.S. exporter or producer that did not comply with NAFTA. So you will be subject to more revisions. I even seen cases that clients in Mexico want to avoid buying to specific exporters or producers in the U.S. which have had problems before with Mexican customs to avoid, reasonably, more verification processes by Mexico. Another consequence of the final determination denying preferential tariff treatment is that the NAFTA certificates of origin issued to the importer in Mexico are deemed invalid. And as I mentioned, because of this, the importer record will be subject to an administrative procedure to determine the applicable duties and fines regarding the goods that were deemed as not originating. Now, this is a hot topic right now in Mexico. Many cases are being litigated because of this, and mainly caused by the problem that the questionnaires were not answered by the U.S. exporters, and the Mexican importers were issued in millions of dollars determinations by customs because of the lack of preferential tariff treatment. So the thinking of Mexican customs has changed in the last year or so. At first, the position was you as an importer have nothing to do. If the preferential tariff treatment is denied, you as an importer cannot say absolutely anything about the origin of goods, because that is you have no evidence to show. That is responsibility of the U.S. exporter or importer. After a lot of litigation, customs was made to change this way of thinking. So even if you get in trouble that you did not receive the questionnaires or somebody did not answer them, good communication with your importers is essential. Your buyers, basically, in Mexico. You must notify them of anything regarding origin verification, because even if by their submissions you as a U.S. exporter get a final determination with a denial of preferential tariff treatment, it is for sure that the Mexican importer will get an administrative procedure initiated. And the new way of thinking of customs is to allow the importers to prove the origin in this 10 days that are given, as we mentioned before in the previous slide, to provide evidence after an initial ruling is made in the administrative procedure. So it's like a second chance to prove the origin. So if you come to notice that questionnaires were not answered and you do receive a final determination in writing denying the preferential tariff treatment, contact your reporter. You can help him prove that the goods are originating. And this is important for the U.S. exporters, because not talking specifically about international trade law, many U.S. importers are being sued by Mexican importers for the misrepresentation of the goods origins or the negligence in not responding during the verification procedures by the Mexican Customs. So you may also get a legal problem with your buyers, not related to customs, but yes, commercially in a legal suit. So it is important to avoid or to always have good contact with the importer and to have good record keeping. So this leaves us, again, with a final determination. In the first three scenarios, we talked about final determinations being made where goods were seized, or where duties were assessed, or where fines were imposed. In the fourth scenario, we talked about a final determination being issued by customs when preferential tariff treatment was denied, which would be the case that would be specifically against your interests and would initiate a further legal action to avoid this preferential tariff treatment. So in this slide, we can now see how the final determinations issued by Mexican Customs in any of the four scenarios can be reviewed in administrative or judicial levels. The first option that we have is an internal recourse, which may be filed with a specialized legal branch of the Tax Administration Service, which we mentioned was that, within 30 working days following the effective date of the notification of the final determination by Customs. The decision issued in the internal recourse may order Customs to reinstate the administrative procedure as appropriate or issue a new determination to replace the contested one. This recourse is optional in most cases. Therefore, the parties can choose to go to the next level of litigation without filing an internal recourse. What are the benefits of this recourse is you keep things in an administrative level. You try to come to a solution with the tax authorities before going to formal litigation. The drawbacks of these is it's the same tax administration which is issuing the final determination in the internal recourse. So many times they just confirm what Customs determines in their final ruling. So it all depends in the specific case when it's a good idea to go through this internal recourse. A great benefit is when taxes and fines are imposed, you do not need to back with a warranty to avoid the forceful collection of these taxes during the internal recourse. So this is the first level. The next level is a decision issued in the internal recourse is adverse, or if you choose to go directly to this level, an appeal or nullity claim can be filed against the final determination with the Federal Tax and Administrative Court, which is a quasi-judicial body. This is the best option in most cases of litigation. It's an independent court with a great legal sense of how to resolve issues in this specific trade. So most of our cases are won in this level of litigation. The third level, it's important to note that this court is not part of the judicial branch. It's part of the administrative branch that depends of the President of Mexico, even though they're clearly independent and they have no way of being involved with Customs in the ruling. So it's the best option for litigation. If the result of this litigation in the Federal Tax and Administrative Court is adverse, you also have a last recourse, which is filed with the Federal Judicial Court, which is part of the Federal Judicial branch of the government, and they will have the final ruling in this matter. During litigation, payment or guarantee of payment of duties and fines may be required by the Tax Administration Service in order to avoid a forceful collection process. So this is one of the drawbacks of further litigation, but many times it's a cost that you have to take in order to bring a case to the proper courts. Payment will not imply consent So it's also an option. Many importers prefer to pay the taxes that were assessed and litigate. And after they get a favorable resolution from litigation, they just ask for the return of the paid taxes, and that works also. So basically, I'm not going into great detail about litigation, but those are the three basic levels that you will see, and are the mechanisms used to resolve problems when you have an issue with Mexican customs. So, just to end this presentation, how to avoid common problems with customs. A few suggestions. Due diligence in preliminary work is essential to avoid delays and customs liability. A good team, importer, customs broker, counsel should be assembled for every export project to Mexico. Request binding rulings when needed. If you're in doubt, it is very probable that customs will try to prove you wrong during verification. Description of goods should always be detailed, and invoices should be easily linked to the information declared in the entry documents. Please, I've seen tons of invoices that use all types of internal codes that nobody understands, and not even customs. So just be as clear as possible. If you're selling fruits, just say, we're selling apples, not code 7760 that means that it's a green apple.
Use.
Yeah? Keep all records to prove the value and origin of goods for at least 5 years. Remember, Mexican authorities normally want to see original documents. This is a cultural thing. Mexican authorities want to see the blue ink signatures and seals in documents when requesting evidence. They presume that all copies are being forged. So that's a way of thinking. And many times in the U.S., it's not really necessary to keep originals in all cases. Well, when you're dealing with exports to Mexico, do keep originals. Even when you're issuing certificates of origin, many times, and I've seen lots of trouble with this, there's a field in the certificate of origin of NAFTA that asks the exporter to declare how they know that the goods are originating. And there's 3 options. They have a certificate of origin issued by the producer that backs the certification. They have a written representation in another form different from a certificate of origin, which this is the case that causes many problems. And third is their knowledge of how the applicable rules of origin were applied. But the second one is the one that causes a lot of trouble, because many times when customs ask the U.S. exporters, okay, you're declaring fee, which means that you have a document that backs the certification that you're doing. And when we ask for that document, many times we receive emails, we receive copies of contracts that do not have signatures. This will not be accepted by Mexican customs as support for the certification, and preferential tariff treatment will be denied. So please, record keeping. Yeah, that's key. Next slide. Also, and I've seen a lot of this, establish measures that will avoid forgery of invoices and certificates of origin by Mexican customs brokers or importers. Know who your buyers are. Know their Mexican customs brokers. Because many times you issue a certificate of origin, and it's really nice, and they include several other goods that are also originating in the same document, and customs will find out about that, or it'll just cause problems, because they'll see different types of letters that are being used, and they'll presume that it's false, so they'll start a verification process with you. Be aware that under NAFTA, Mexican authorities can verify origin of goods exported to Mexico in U.S. soil. Never certify a good as U.S. originating unless you have the proper documents to back such claim. Also, in the U.S., there's prior disclosure. In Mexico, this does not exist. It is not available. So if you go to the Mexican customs authorities to disclose your problems, it will not avoid any liability. It will most probably cause an audit or a verification. It's not like the U.S. So keep in mind that even when I say this, there are also taxpayer right laws that do permit self-correction during audits to reduce penalties. So If you're being audited, it's not the end of the world. You can come out with a good solution with customs. And nobody's perfect. If a problem with Mexican customs arises, rest assured that in Mexico you can find an impartial and corruption-free administrative and judicial review of federal courts. I cannot say that of the internal recourse, but at the last two levels that I mentioned, I think it's a great chance that you will be attended with proper legal knowledge about the case. Now, it is also very important to mention, if you get a final determination that denies preferential tariff treatment, you as a U.S. company or individual can litigate directly in the Mexican courts. You can file a nullity claim, no problem. I've seen it in lots of cases, specifically in origin verification cases. And U.S. companies do this because they want to avoid their liability with their buyers. So they want to help their buyers in a certain way. Many times, okay, I didn't answer. Now I know about this, and I want to prove it. So they provide evidence in this nullity claim. Or when they do answer and they're not, and Mexican customs deny the preferential tariff treatment, they have to give you in writing the reasons for doing so. So you may not be in the same page with them, and you can claim that they're wrong. So the key is get Mexican counsel for this. Many times, and I've worked with a lot of U.S. lawyers, they try to convince their clients in the U.S. that the NAFTA rules work the same in Mexico as it works with CBP, and that is just not true. It's the same treaty. Each country establishes their separate rules to apply that treaty, and the way of thinking and applying them many times are different. So it is very important to get Mexican counsel to help you out with this. You can have your U.S. lawyer contact the Mexican counsel and together work something, but it's essential to have Mexican counsel. So that is all I have for you today. I hope this information was helpful. I will try to answer any questions you may have in the time we have left, but please don't hesitate to send me an email if any doubts come up in the future when you review this presentation.
Thank you very much, Carlos. And now we will begin our question and answer session. Once again, if you have a voice question, please press *1. And then after voice questions, we will go to the written questions. So I'll go back to the operator. So, operator?
Thank you. If you would like to ask a question, please press *1. Please unmute your phone and record your first and last name, as this information is needed to introduce your questions. Once again, if you would like to ask a question, please press *1 on your touchtone phone. One moment, please, for our first question. And our first question comes from Mitch Kostelakis. Sir, your line is now open.
Thank you. I was participating by phone, so I didn't see the slides. I was wondering if you could read the URL for the website that was referenced.
Okay, I think someone is going back and trying to find that URL.
Okay.
Manuel?
Yes?
Can you find that URL for this gentleman?
Yes, of course. Let me check.
The first slide, I'm not sure if it's there.
Okay.
Sir, I'm sorry. Can you please repeat your question?
Yes, I'd like the URL for the website that was referenced.
He basically needs the link to be able to see the slides, I guess.
The link.
I understand that it's the Mexican Customs site, no?
Yes.
Yes. I remember. Actually, let me tell you.
I see this link right here. This link?
This one. Yes, that's right.
Is that what?
Yeah, I can't see it. That's why I'm asking. I'm not. I'm just getting that home.
Okay, it's www.siicex CAAA as in apple, REM as in Mary, .org dot M as in Mary, X as in xylophone. I'll repeat it again.
Okay.
The information that you're looking for, it's www. S, I as in ice, I as in ice, C, E as in elephant, X as in xylophone, dash, C as in cat, then A, another A, R, E as in elephant, M as in Mary, dot O, R, G, dot M as in Mary, and X as in xylophone.
Thank you very much.
Okay, no problem. And just as a reminder, we're going to send everyone a copy of our PowerPoint presentation slides as well as our net recording. So we will definitely provide you with this information that is on these slides.
Okay, good.
And we'll also answer, any questions that you have, written or oral. So if you have any more voice questions, we'll be happy to take them. Okay, we'll continue on then. Thank you very much.
I think there were some questions, written questions, right?
Right, but I'm offering the audience for some voice questions. Any more voice questions?
No questions in the queue at this time.
Okay, thank you. Okay, great. Now we'll go to the written questions. I have a question here from David Robles. The question is, does Mexico have a database in which you can search previous binding rulings issued?
Yes, they are very general. You won't see specific because, as you remember, when you file for an advance ruling, you have to be very specific about the case. But when Customs sees a repetitive question in the same order, they will publish a compilation of favorable resolutions for the taxpayers. This can be found in the Tax Administration Service website. If David wants to send me an email, I can look up the link for that, but they do exist. It's not a database specifically, it's just a publication. So
in Spanish.
In Spanish. So you have to go through, it does have an index to see which areas there is. Yeah, exactly. But they do that, yeah.
Okay, great. Thank you very much. Next question I have here is from Valerie Kimber Roy. The question is that there's a 2006 ruling on a U.S. NAFTA customs certificate which made electronic and mechanical signatures acceptable. We have Mexican customs brokers rejecting our NAFTA certificates, asking that we carrier the original certificate with a signature. Do they have jurisdiction over the rules over a U.S. customs form?
Okay, I understand that this is a U.S. ruling. The thing is, again, the cultural thing that we have. It's not that they have jurisdiction over the rules for a U.S. customs form. The thing is, the Mexican importer is applying for preferential tariff in Mexico using this document. So customs in Mexico expect to see a blue ink signature on the certificates. Many times I've seen, and the thing is, when you do the import process, they only ask you for a copy of the certificate. They don't ask for the original. When they doubt of the authenticity of the document is when they require the importer for the original document. And for them, the original document is the blue ink document. So many times this causes trouble because they say, you have a copy. It's not an original. And a CBP ruling about that will not bind Mexican customs. So the problem is for the Mexican importer. That's why they ask for this. That's why the Mexican customs brokers are rejecting them, because they know how Mexican customs think. What they can do is ask for a ruling for Mexican customs in order to have an answer from this. I've never seen that before. Most of the cases, as Valerie is seeing from the Mexican customs brokers, they require the ink signature in the certificates.
To avoid problems.
To avoid problems, because it's a cultural thing. We are more propense of fraudulent forgery documents. It's not. It's just a trust thing. Yeah.
Suspicious. Suspicious man.
I'm not sure if this is a sufficient answer for you, Valerie, but there's an email. You can contact me for more information. But basically, I understand. It's not that they have jurisdiction over the rules over a U.S. customs form. It's that they're using it with Mexican customs, and they expect to apply their rules. Okay.
Excellent. Thank you very much, Carlos. And I don't see any more questions here, and here comes another question, written question. And I'd just like to let the audience know that, we have Carlos here. He is our expert in this area, so please take this opportunity to ask a voice question, because this is why our webinars are very beneficial. You get this live interaction with the presenter, and this is our last of this series. So please ask your question. I'm going to open it again for voice questions, and then after that, we'll conclude with any written questions the audience has.
Again, if you would like to ask a question, please press star 1 on your touch-tone phone. Please unmute your phone and record your first and last name. Once again, if you would like to ask a question, please press star 1 on your touch-tone phone. One moment to see if we get any questions. Thank you. Our next question comes from, I apologize if I mispronounced the name, Masmode. Sir, your line is now open.
Yes, thank you. Just I have a question. If I can have access to the website, the Mexican requirements website, like in order to be able to see what are the requirements for each product.
Yes, it's a CSEX website that the link is in page 8.
It is the same one?
Yeah, the same one. You go there. Actually, there's a specific. It's in Spanish. The only thing. Do you have access to internet here just to see the specific part of the website? No, we can move it. But on the top side, on the top of the website, you'll see several bullets that talk about different areas of the website. You need to press the one that says tarifa, which is equivalent to tariff.
Okay.
And that automatically and for free, with no password, will open up the complete harmonized tariff system for Mexico.
The first thing is they need to know the HS code of their product.
Of course.
Right?
If you have the HS code, you will be able to from that system, open the specific code, and that will give you all the duties that are applied, even the preferential tariff treatments of all the world with all the treaties that Mexico has negotiated, and the non-tariff barriers that are applicable. It is in Spanish, but it is a great tool.
Do you guys have the version in English?
No, because I'm not sure if the Ministry of Economy has translated, but I don't think so. It should be in Spanish.
I see that there's some databases that you pay for that, like El Día database, but you need to pay then a fee for to have access. And it's the same. You provide the HS code, and with the HS code, you have some information. But in any case, my recommendation in this case is that you get in contact with a custom broker, because like Carlos told us, probably there could be some changes in the HS code. You could have an HS code, but in Mexico probably could change. And this is why that probably you require an expert to help you to classify your products.
Yeah, but for a preliminary analysis, this website is really great. It's really great because it gives you the complete description of the goods also that will be declared in the entry document. So use it. And if you have doubts of a specific translation, you can get also help from the Mexican Customs Broker or counsel that can help you translate what you are seeing in CSEX once you're doing your preliminary work before exporting to Mexico. But I'm absolutely sure that the Ministry of Economy does not have this website in English.
Mm-hmm.
Okay. I have another question.
Sure.
Go ahead.
Do you know what are the, how you say it in Spanish? I can say it in Spanish. I don't know how to say it in English.
Okay, go ahead in Spanish.
¿Cuál es, por ejemplo, cuando tenemos broker en Laredo, pero me gustaría saber para mi información personal cuáles son los productos que están prohibidos, por ejemplo, que si es lobster o camarones de China o de cualquier otro sitio que no lo puedo enviar, También en esa página web figura cuáles son los productos que no puedo enviar.
Sí, claro. Yeah, he's asking if in CSEX we can find a list of prohibited import goods.
And the ports.
And the ports. The ports.
Yeah.
The authorized ports, which they can be imported. Well, there's a very important thing. The last changes in the customs law opened up most of the ports for all products. So that limitation, those regulations are not found in CSEX. Those are found in general rules published by the customs authorities.
And where I can find it, where I can find this information.
You can find that in the Tax Administration Service website, that's SAT, www.sat.gov.mx, and there will be a microsite for customs, and you will be able to find there all the regulations. So there's a specific link for customs regulations. Okay. It is all in Spanish.
Even they can call them and they could ask directly. But it's in Spanish, the attention for the Mexican.
Yeah, but that will be found. And there's basically each year they publish them. We're still pending on the 2014 ones, but the 2013 ones already include some of the changes in the last amendment of the customs law. And one of the objectives of this amendment back in December was to make it easier for the importers to make the import process. And one of those mechanisms created by the new law to make these things easier is to avoid limiting certain ports for the importation of goods. But again, your Mexican customs broker is for sure aware of these changes and can tell you exactly the ports that you can use to import those type of goods.
Okay, so that said, I think a particular product can be shipped in one port and the other they would refuse it. Is that correct?
Yes, that was the way it worked before. But I'm pretty sure that all ports are not authorized for all goods. But I would recommend. I don't have the law here at hand to tell you specifically.
Okay.
But that was the objective of the amendment. So I'm sure that these restrictions were lifted.
Okay.
Okay.
Thank you.
Welcome.
Our next question comes from Mr. David Robles. Sir, your line is now open.
I have a question. The issue is that we have a related company in Mexico, and we are not a manufacturer, but we are a distributor in the U.S., and we get certificates of origin from our suppliers, and we, of course, use the harmonized code that the supplier provides on the NAFTA, but the customs broker of our subsidiary in Mexico is saying that classification is incorrect, and we have to remove the NAFTA preferential duty treatment because the certificate becomes invalid. And what would you suggest on that? Should we follow the opinion from the customs broker, or what we can do? In some
Get counsel. Get Mexican counsel for that, for the specific tariff classification at first. And if doubts persist, use the advanced ruling procedures for the classification process. You know what? The thing is, Mexican customs brokers are liable in their operations together or along with the importers. So many times when they see something that they don't like, they would recommend something to avoid liability. It is easy for them to say, no, don't apply the preferential treatment because I'm not sure that that's the correct tariff classification. And the easy way out for him is to avoid the application of tariffs, but your related party in Mexico will have to pay for the duties.
Yeah, in that case, they will be paying for the duties, and we just don't have any resource available to dispute that because.
And have you asked for an opinion of another customs broker?
No, not really. We just have one broker our sister company only has one registered customs broker, so all the shipments go through that agent. So I was really wondering if we could get, like in the U.S., examples of previous rulings and see if we get a feeling that the broker is correct on its assumption or count.
But you can ask the broker, but because if the broker is saying that the tariff code that you are using is incorrect, therefore he must have the correct one in his opinion. So you can ask the broker, okay, so if you consider that the applicable code is different, give me your reasoning and backing of such reasoning in the law to determine that yours is correct. And therefore you can have the sufficient information to be able to review with independent counsel, maybe even in the U.S. You don't have to hire a Mexican counsel for that. The harmonized code is the same for both, up to 6 digits. And in most cases, the majority of cases, NAFTA certificates only require the declaration of the tariff code up to 6 digits.
Yeah, but in this case, they are going with a different code to the first 6 digits. So it is a totally different harmonized code. So it's not that we are departing on the opinion at the statistical level, which will be the last 2 digits of the HS code Mexico. It's the whole subheading to the 6 digits that is completely different.
So with this, I understand that
so
the Mexican customs broker is saying that it's a different code.
They are calling a piece of furniture that has a wood surface as a furniture of wood, but in the U.S., the supplier is telling us that piece of furniture, since most of the components are made of metal, it's considered a furniture of metal. So we are talking about 2 different HS codes. It's 940320 for furniture of metal and 940360 for furniture of wood. So
fine products are the ones that make most trouble, precisely because 2 or 3 may be applicable. The thing is to apply the correct rule to be able to determine which one is the one that makes the product what it is according to its use, or the product that gives the good the
essential character. They are saying that the essential character is given by the surface of the product, which is wood. But
I bet you this. I bet you that the product requires a non-tariff barrier that the custom broker is worried that it would not be complied if you use your tariff code. Is that the case?
Well, they never had mentioned anything about a barrier on the product because it's just a workbench. So I doubt there is a barrier against a workbench. But
the raw materials that are used many times require permission by SAGARPA, which is the authorized, to avoid plagues and those type of things.
Yeah, if it ends classified as furniture of wood, it goes through a wood inspection at the border, which I wouldn't have to have if it was considered furniture of metal. But the issue really is the classification. How can I really get an official opinion about that? Do I need to ask my
No, go ahead and do an advanced binding ruling with Mexican Customs. Now, the way this works is you have to do it before making the import process to Mexico.
Before making the import process. Okay. So
but the law allows you to make the import process to Mexico, but you have to apply the tariff code that has the higher restrictions and duties of the 2 that are in question, in order to avoid delays. And if the ruling is favorable to you, you would get the duties back. Of course, the compliance of NTBs, well, that's done, right? But also you could wait for the ruling, and you can
the advance binding ruling, the company in Mexico or the U.S. exporter? Who gets the opinion from SAT?
In article, if you have the Mexican Customs Law, it is regulated in Article 47, and it explains the complete procedure for this.
Okay. Yeah, I just wanted to get some guidance on that, because we always get sometimes those differences that are pretty significant in terms of the classification. Of course, we rely on the expertise of the broker, but sometimes it's hard to understand their opinion or their point of view.
Exactly. And again, they are worried about liability, and specifically when non-tariff barriers are involved, even they could lose their license if they are not compliant. So you can imagine what they have at stake. So it's understandable by a certain point of view, but this provides a lot of problems for trade.
Okay, perfect. Thank you very much.
There are currently no more questions in the queue.
Okay, and we'll just take then one last written question. This is the last question for this webinar. This is from Cynthia Dixon. She says, if there is an issue with the tariff code on a NAFTA certificate where the Mexican broker does not agree, then they must have a tariff that they believe is correct. My suggestion would be for the U.S. exporter to review the tariff for rationale of tariff and then the rule of origin for the Mexico tariff being offered. And if the goods meet the rule of origin, then issue a new NAFTA and make note to the records why the tariff number change is being made directly on the NAFTA certificate. Is this also an option?
It's a great suggestion. It's right on the money. It's actually what we were saying in the last question. You have to review the rationale of the custom broker. And if it's the correct tariff classification for Mexico, the U.S. exporter will have no trouble in a case of an origin verification. And it's perfect to have records. I was stressing about good record keeping. Even if they are not or not fully agree with the rationale of the customs broker, if that will be an issue to avoid the sale of the goods, I understand that you can do this. And if you have good record keeping of this issue, it will help customs understand in case of an origin verification. But it's a great suggestion, Cynthia. I think you could do that. It is an option.
Well, great. Thank you very, very much, Carlos, for your time. And everyone, I'm afraid that is pretty much all the time we have for today's webinar. Remember, for those of you who might have questions after this webinar, please note this contact information that is in front of your screen. Please feel free to write down this information and contact them either by telephone or email. Our main speaker, Carlos, of course, and also if you have any questions about the U.S. Commercial Service and the products and services that we do here, you can also contact Manuel. I'd like to thank everybody for joining us. Once again, thank you, Carlos, for your time and expertise. Also, thank you, Manuel, for helping me with this entire webinar series. It's been fun. We've completed our series of 7, and this is the last one for this fiscal year. And also, thank you once again to all of our participants. You've always been very loyal, and you've actually helped us to understand more how we can help you. So please check your email boxes for more information on our upcoming webinars, and thank you very much again for joining us. And thank you, everybody, and that concludes our webinar. Goodbye.
Thank you for joining. This concludes the conference call. All parties may disconnect at this time.
Operator, are we in the pre-conference?
I'm sorry.
Fantastic. Thank you.
Thank you. I'm moving you now. Give me 1 second, okay?
Sure.
That's okay. That's quite all right. I don't know if someone made a mistake and took it down because they thought we were going to know. Here it is. Hold on.
Okay.
Enter your